I've had a chance to review the motion, Your Honor.
Thank you, Attorney Felton. We will take up the motion that was filed this morning first. You may be heard on the motion.
Thank you, Your Honor. Maybe I misunderstood yesterday when Ms. Almeida was testifying and she was explaining what she said, and I had objected on the grounds of hearsay, and I believe that Your Honor had indicated that because she was present and able to be crossed, that it did not constitute hearsay. If there's another reason why it should be admitted because there's an exception to the hearsay rule, or it's not hearsay because of something other than the fact that she's present and able to be crossed, that I understand. But I would like to ensure that just because she is here, that does not mean anything that she had said outside of court constitutes non-hearsay.
Well, this is a motion in limine to preclude certain evidence that the defense considers hearsay. And the court is not inclined to rule in the defense's favor on a motion in limine to preclude hearsay statements, because as those statements or as those questions are proffered, the defense has an opportunity to object. The court will take up the objection when the objection is made.
Thank you, Your Honor.
Our counsel prepared to argue the motion concerning the STR mix evidence.
Yes, Judge.
Thank you. First, the court recalls that the defense had indicated that it would essentially challenge the STR mix evidence by way of a Porter hearing. First, is that the defense's position today?
I've had some opportunity to discuss this with Mr. McGinnis. I am not seeking to preclude any evidence from the STR mix program. I've had a fair amount of opportunity to research, read up about it. My claim is more narrow, that there needs to be a Porter hearing on the so-called likelihood ratio. I'll just be clear on what I'm not challenging. I'm not challenging the fact that this program does what's known as a deconvolution analysis. It takes what is essentially multiple depositors of DNA and runs a number of odds, for want of a better term. In other words, it takes mixed DNA that could be anywhere from 2 to 6, 7, 8 different depositors of DNA, touch, any kind of fluid, anything that sneeze, anything that has DNA in it. It determines, based on certain input by the lab assistant, that they determine how many contributors they estimate. This program then runs statistics, thousands, hundreds of thousands, I think in some cases millions of scenarios, and comes up with odds, and that's why I'm challenging this part of it. What the odds are that one scenario, that is the prosecutor's theory, is more likely than the defense assumed theory. Again, they don't necessarily know what our defense theory is, but they put in a suggestion that maybe it's someone else's or it's a third party's or whatnot. So this program, which is proprietary from a New Zealand company and no one has access to, again, the only scientific studies of validity have been conducted by a team that's made up of the company's vice president. There has been no independent study. And I'll just say this. The PCAST report, that is the president's Commission on the Admission of Scientific Testing concluded in 2020 that STR mix has promise, but there are no scientific validity peer-reviewed studies. There are only studies that have been conducted by the company itself and people that they themselves have brought in. So the only portion for this hearing and for this trial that I'm challenging are the odds. In other words, this computer runs I think it's called the Markov Monte Carlo analysis algorithm. It's the same, not exact algorithm, but the same process that's used to calculate the odds of winning the lottery, the Powerball, when it's $1 billion. So the problem with that is that just because they're giving out odds doesn't mean that only 1 in 1 billion people could win. If that were the Powerball, if that were the case, that if it happens that 2 people guess the numbers, the misconception is that, well, someone must have cheated, someone must have gotten the numbers in advance because the odds were 1 in 1 billion, and here 2 people in 1 billion got it. So my concern has to do with these numbers. These are not these numbers do not mean that it's 100 billion or 10 billion or in one case, 250,000 to 1 that a particular
off my student loan, which is an absolute lie, and that he was going to make sure that I never see his kids again, but yelling in front of the kids. So it was very uncomfortable.
Did you ever do a drop-off with the children again?
After that time, no. I told her I no longer wanted to be around him.
Did Jennifer and Mr. Doulos ever officially finalize their divorce?
No, they did not.
Was their divorce ongoing in May of 2019?
Yes.
In May of 2019, how often was Mr. Doulos permitted to see his children?
He had supervised visitations, so he had to have someone from the court along with his visitations, which was every Wednesday for a few hours. And with that visitation, it needed to be agreed upon with the supervisor and Jennifer through something I believe was called the Family Wizard, for them to communicate, because they no longer could communicate through text or through phone. Everything needed to be recorded. So it was supervised visitations once a week.
I want to direct your attention now to the week of May 20th, 2019.
Mm-hmm.
Were you working as a nanny for Jennifer during that week?
Yes.
And I want to begin with May 21st, Tuesday, 2019.
Okay.
Where were Jennifer and the children living at that point?
So they now have moved to 69 Wells Lane in New Canaan.
Did Jennifer own that home?
No, she was renting.
In addition to yourself as the nanny, were there any other individuals who were frequently in the home besides the family itself?
There was a cleaning person that would come often. Her name was Edie. I don't know if it was like once or twice a week.
And how often were you working for Jennifer in May of 2019?
So the weekends were less, but it was usually Monday through Thursday and Sunday most of the time. But I would always have Friday and Saturdays off.
Had you had any contact with Mr. Doulos from September 2017 until May of 2019?
He was emailing me back and forth.
But other than that?
Other than that, no contact.
How did you typically get into the house at 69 Wells Lane?
So they had a 3-car garage, and I would enter through the middle because they had a keypad, and that's what the keypad would open. And I would enter through the garage, and then there was a door that led to the mudroom, and that's how I would get in the house.
What types of vehicles did Jennifer own?
So she had a Suburban, and she had a Range Rover.
Where would she typically keep the Suburban and the Range Rover?
So the Suburban was on the left side of the garage, and in the middle was the Range Rover. And then the third and last bay we had a bunch of shelves for sporting equipment and the garbage can, so that was typically left open.
Are you familiar with something known as WeatherTech lining?
I think that's like a Suburban or line your cars with. Maybe not. I don't know. I think yes.
Well, let me ask it this way. Did Jennifer have lining in her Suburban?
Yes.
Where was the lining?
It was in the car, so it was like the mats and then the trunk because the kids would throw their sports stuff in there all the time. So it was like, I think, a way to protect the car.
And had you actually seen the lining in the trunk of the Suburban?
Yeah, it never came out of the car unless she brought it to a car wash and they took it out to clean it, but they always put it back in.
What type of material was this made out of?
Like rubber.
When you would enter through the garage, you indicated that you accessed a mudroom. Is that correct?
Yes.
Was the door to the mudroom ever locked?
No, that was kept open.
When would it be locked?
The door leading into the garage,
Yes.
that door was never really kept locked. It was kind of just open.
Now, I want to direct your attention to that day, Tuesday, May 21st, 2019. Was there a basketball hoop being installed at the residence?
Yeah, so the boys got a basketball hoop as a gift from their grandmother. So they were getting it installed in their driveway. It was one that you had to dig a hole for and put it in that way.
And were you present when that was taking place, the basketball hoop being built?
No, I showed up after, so it happened earlier that morning.
Did you have a conversation with Jennifer about the garage that day?
Yeah, so she went to show me the basketball hoop because she was like really proud of it. So we were on our way outside and just in passing, she's like, this is a mess.
Objection, Your Honor, hearsay.
But the hearsay came in at the end of the question. What is the question?
Whether or not she'd had a conversation with Jennifer about the garage?
So the answer was yes. And then the response was, she said, hearsay.
Well, my response, Your Honor, is that I'm not offering this for the truth of the matter asserted, and so I'm not offering it for a hearsay purpose. It's meant to explain why this witness took subsequent action in the garage.
The counsel approach, please. You may ask a question.
What did Jennifer say about the garage?
She said the garage was a mess and that was it. So I decided to clean it that day.
What area of the garage did you clean?
I cleaned that third open bay that had all their sports equipment in it.
And how did you clean the area?
I guess it was just more like organizing the shelves and organizing what was on the floor and just putting things in certain spots.
Were there any cleaning supplies in the garage?
Yeah, there was a bucket of cleaning supplies.
What color was the bucket?
To be honest, I don't remember. I believe it to be white or red.
Can you describe the bucket for the jury? I mean, is it one of these 5-gallon buckets or?
Yeah, it was one, like, I guess it's 5-gallon. I don't know. But it would just have things like Windex and cleaning solutions, sponges, things like that, that the cleaner would use, like grab on into when she would enter the house to clean the rest of the house.
And while you were cleaning the garage, did you notice any camping pillows?
Yeah, so the kids would go on a day-night trip with their school where they had to bring camping supplies, like a camping pillow and sleeping bag. So I kind of put that in the corner. It just kind of lived in the garage.
So the camping pillows were in the garage?
Yes.
Now I want to direct your attention now to the next day, Wednesday, May 22nd, 2019. Were you working that day?
Yes.
And what time did you arrive at work?
I usually arrive around 12-ish. It depends. Sometimes I come in earlier.
Do you remember what you did upon your arrival at work that day?
On Wednesday? Well, Jennifer, there was a visitation that day, so I usually go to the house first and kind of like pick up after the kids or their rooms and stuff. So probably like made the beds.
You mentioned that there was a visitation that day. Who had visitation?
Fotis had visitation.
And what time would Fotis arrive for visitation?
4:30.
And what time did he arrive on this day?
This day he arrived at 4.
Was this unusual?
Unbelievably unusual. Fotis was notoriously late to everything, including supervised visitation.
Did you see him arrive at the house?
I didn't see him arrive at the house until Jennifer noticed him through the window because he pulled in up the driveway, and part of their agreement was that he had to wait at the bottom of the driveway for the supervisor to arrive, and then together they would drive up the driveway and get the kids for the supervised visit. So it was strange that he drove his car all the way up the driveway with nobody noticing. So Jennifer saw that he came down and got me and said, she just said, I'm going to go talk to him and see what's going on. And he said he was confused. And so he just went back down the driveway and waited for the supervisor to arrive.
Now, at some point, did you leave did you leave 69 Wells Lane?
Yeah,
Why did you leave 69 Wells Lane?
I didn't want to be around Fotis.
So what did you do?
I went into town with one of the kids. I think we grabbed lunch. I believe she had, they did horseback riding. And so we were going to that right after. So we just grabbed something to eat. And then I took her to where she needed to be.
And how long did that last where you took her out on to, what was it again?
I think it was horseback riding.
Okay.
Yeah,
How long did that last?
It's usually like, I believe it was like an hour and a half or so.
And at some point, did you message with Jennifer?
Yes.
And what was the purpose?
And where the device had been hours earlier.
How did you determine where the device had been hours earlier?
Through the location data of the phone.
And so, can you just explain to the members of the jury how you're able to do that?
Well, again, I'm going to object. He testified he didn't do it, and it's not even his program. So I think this is the wrong witness for that aspect of it. I certainly didn't object to the general explanation of what he brought and saw someone do, but now for asking him to interpret the data is where I object. I couldn't cross-examine this witness about specifics without actually having those documents through the witness who produced it. I may not require that person. I'm just saying I don't think he's the right person.
Right. Well, it would appear that the question the court would have is, how does this mapping of a device work such that you can follow it over the course of a number of hours?
Try to ask the judge this question. How does the mapping work so that you can follow it over a number of hours?
I'm not